And welcome. I'm Marco Sassoli. I'm director of the Geneva Academy for International Humanitarian Law and Human Rights, which is a joint center between the University of Geneva and the Graduate Institute for International and Development Studies. And I'm very pleased to welcome you today to a very special session, because although we are near the lake, we are very far from the sea, and therefore we probably don't deal enough with maritime questions. I must say that I was always fascinated by, although I don't know anything about it, by maritime safety law, because as an international law professor, but you will correct me today, it seemed to me that it works. And the best proof that it works is that it has led European states to do everything possible not to come into the situation where they have to comply with the obligations, which means that if they come to this situation, no one contests that they have to rescue, and therefore obviously this is a combination with the efficiency, I would say, of the European Court on Human Rights, which has developed a clear jurisprudence which said that once you are rescued by a European ship, you are under the jurisdiction, which is logical for international lawyers, of that state, of the flag state, and therefore you benefit from the human rights non-refoulement principle and from the procedural guarantees under the European Convention and its additional protocols. And even those who are considered today the worst of the worst, the smugglers of human beings. I remember some places in the Swiss Jura where there are monuments for the smugglers during the Second World War, but this is how times change. But even the smugglers understand maritime safety law, because they smuggle the people in non-seaworthy ships, because they understand that if the ship was seaworthy, there wouldn't be an obligation to rescue the people who are on the ship, and therefore the whole system combining maritime safety law and human rights law would not work. I'm impressed because in my field of specialization, which is humanitarian law, I would be happy if the law was taken so seriously then apparently by people who work and travel at sea, also in conformity with long-standing traditions. But you didn't come here to listen to me, but to mainly Andrea Pappalardo, who is practicing maritime law as an attorney here in Geneva and in Naples, and before this has led the legal department of an important shipping company. And there will be comments to what he will explain us by Professor Vincent Chetaille, who is the director of the Global Migration Center at the Graduate Institute of International and Development Studies, who heads the International Law section at the Graduate Institute and will soon chair the board of our academy. And my colleague Anissa Belal, who is strategic advisor on IHL and senior research fellow, will chair this meeting. Welcome, thank you to have come to this interesting discussion.
Thank you very much, Marco. I will also take a few minutes to introduce to you the IHl Talks initiative that we hold here at the Academy. This is the first IHl Talk of 2019. IHl Talks are regular events that are held during lunchtime to discuss humanitarian action issues, not necessarily focused on IHL, but more on humanitarian topics. The next one will take place on the 4th of April on the rights of persons with disabilities in armed conflict situations in the context of a research project led by my colleague Alice Preedy. And the further one will take place on the 2nd of May on the issue of starvation in non-international armed conflicts. So you are most welcome to attend also these events. If you have not yet registered to our newsletters, please do so that you'll be kept informed of these two events. In 2018, more than 2,000 refugees and migrants died or went missing across the Mediterranean Sea, as cuts in search and rescue operation reinforced its position as the world's deadliest sea crossing. But as reminded by Filippo Grandi, the UN High Commissioner for Refugees, saving lives at sea is not a choice nor a matter of politics, but an age-old obligation. As reminded by Professor Sassoli, today we are going to discuss the legal framework surrounding search and rescue operations with two of the top leading experts in this field. I'm going to give the floor first to you, Andrea, and then the discussion will be, your presentation will be discussed by Professor Vincent Chetal. So the floor is yours. Thank you.
Thank you. First of all, good afternoon to everyone. Please allow me to thank Mr. Sassoli and all the Academy for giving me the possibility to be here with you and to share the floor with such a distinguished panel of speakers. As you all know,
perhaps if you can speak a little louder for the lady in the back.
I hope the good afternoon was at least heard. So good afternoon to everyone. I was just thanking the director and professor, Mr. Sassoli, for giving me the possibility to be here with you today and to discuss such an important topic like the search and rescue obligations at sea, which is or seems to be a hot topic, although of course migrations at sea in specific reference to Mediterranean Sea, and so as a consequence all the obligations regarding search and rescue are surely not something very recent. If we just consider that in the last thousands of years, I don't know how many times, of course, there have been trips across the voyages and migration flows across the Mediterranean Sea. And so this kind of activities and obligations have been, of course, discussed. I've just chosen 4 images. 3 of them are artworks. One is a photo. And just in 1 minute, the first one actually it belongs to legend more than history. It refers to the trip made by Aeneas, more or less 1,200 years before Christ, when Aeneas left Troy to cross the Mediterranean Sea westbound to reach the current Italian coast. And several centuries later, just after 1492, non-Catholic communities were forced to flee Spain because of persecutions, and so in that case they were obliged to cross the Mediterranean Sea but eastbound. And then again we have the third picture a few centuries later, between the 19th and between the 18th and 19th century, when because of the poor conditions of life, people from Sicily had to cross the Mediterranean Sea southbound to reach Tunisia with the hope of new job and life opportunities. And then we arrive, of course, to nowadays, when, of course, most of the routes are from the North African coast to the Southern European coast. This is just to give 4 examples between legend and history of how many times and in how many different directions the Mediterranean Sea has been crossed. And maybe not really by coincidence, a philosopher like Hegel, who lived between the 19th century and the 18th century and 19th century, used to say that the Mediterranean Sea was the axis of the world history or the navel of the earth. And maybe it's not a coincidence if Mediterranean means between the lands. But however, as has been already mentioned, today the Mediterranean Sea can unfortunately also be considered a sort of graveyard because of the huge number of deaths due to also the lack or absence of measures to avoid or minimize as much as possible the risk of people crossing the Mediterranean Sea. If we just take the 2018 year, more or less have been estimated 2,300 people who have died, who went lost. So, given this, starting from these figures, we will have not more than 40-45 minutes, and we will try to share together the main concepts. So we'll try to provide the answers to a few main questions, which you can see on the screen, or at least to share some keys of analysis to understand a bit more about the search and rescue obligations at sea. The presentation will be divided more or less in three parts. The first part I will try to provide, or at least to identify the main key concepts under the main legal instruments, so with a specific reference to international legal conventions and a non-binding instrument, which are some IMO guidelines, which we will see in a minute. Then in the second part, we will go a bit deeper into the analysis, and we will try to understand a bit more about the open issues, the unresolved issues. There are different. I've just chosen for time constraints a few of them, and then in the third part we will go through a few cases, through a short list of cases, to provide more complete perceptions of the concepts shared with you today. So, as has been already mentioned by Professor Sassoli, the duty of solidarity at sea, and so the duty to render assistance at sea, is really a customary law principle. It's a principle which has never been put in discussion by the seafarers community. It's always been spontaneously complied with, and it is of course the underlying principle of many obligations which we find, which are enshrined in most or many, at least, international legal conventions. We can start immediately saying that there are different actors, of course, involved in the search and rescue procedures and process, namely, of course, the shipmasters and ship crews, the coastal states, and the flag states under whose laws the ships are registered and operate. So let's start to see which are the main obligations which stem from the principle of solidarity at sea. You will see I anticipate a few terms which I will repeat many times during the presentation, but these are really the main concepts which deserve attention to start analyzing this legal framework. So we can immediately start saying that the duty to save life at sea applies in all maritime zones, independently of the nationality or status or circumstances in which survivors are found. The master's duty to provide assistance is with all speed, but always taking care of the safety of the ship and the crew on board its ship, unless the ship is unable or the master considers it, so the intervention, unreasonable or unnecessary. So you can immediately see how is important, of course, the perception from the master's point of view of the danger, of the distress, as we will see later on. And then the last of this short list of main obligations is the duty to deliver survivors to a place of safety as soon as reasonably practicable. So once identified the main obligations, we will dedicate a few minutes just to read very short extracts of some articles which reflect these obligations. This is the list of the more often mentioned legal instruments. So you can see that 4 of them are international conventions. So the UN clause signed in 1982 in Montego Bay, where UN clause stands for United Nations Convention on the Law of the Sea. Then we have the SOLAS Convention, signed in 1974, where SOLAS stands for Safety of Life at Sea. Then we have the SAR Convention, signed in Hamburg in 1979, where SAR stands, of course, for Search and Rescue. Then we have the IMO Salvage Convention, signed in 1989. And then we have a non-binding legal instrument, which is represented by the guidelines on the treatment of rescued people at sea, adopted by issued by the IMO in 2004, together with a few amendments to the SAR and SOLAS conventions. This is the first of the few articles I will show you today, and you can see immediately in bold or underlined the principles, so the main keywords, which all refer to the obligations we have mentioned a few minutes ago. You can see that in this case, Article 98 of the UN clause, which refers to the duty to render assistance, refers to obligations to states. So in the first paragraph, you will see the obligation for the flag states to require the master to render assistance to any person found at sea in danger of being lost, and to proceed with all possible speed to the rescue of persons in distress without serious danger to the crew and the passengers. While the second paragraph refers to always to state, but coastal states, which whose obligation is to provide an adequate and effective search and rescue services, if possible by way of mutual regional agreements. If we then go to the Article 10 of the IMO Salvage Convention, you can see the same kind of wording of the previous article, although in this case the provision is addressed to the master in particular and not directly and on to states. So the obligation is always to render assistance to any person in danger of being lost at sea. Then we go to the SOLAS Convention, Chapter 5, Regulation 33, makes reference to, again, to the obligation of the master, who is bound to proceed with all speed to the assistance of persons in distress, regardless of the nationality or status of the persons. And as far as the governments are concerned, they shall coordinate and cooperate to ensure that masters of ships providing assistance by embarking persons in distress at sea are released. This is something which we'll see, of course, more in details later on, from their obligations with a minimum further deviation from the ship's intended voyage, so to arrange disembarkation as soon as reasonably possible. So we have in this first 15 minutes, I think, identified a few of the main, so the key concepts which concern the search and rescue obligations at sea. So maybe now we are ready to go a bit more into details in our analysis, and we will do that by the definitions given under the search by the SAR Convention. To start to put on the table a few questions. So let's start from the definition of search. Search is the operation coordinated normally by a rescue coordination center. So we know now that normally the authorities who take care of the SAR operations are the rescue coordination centers. So to locate people in distress. So we start look at this word distress, which we will discuss more in detail shortly. Then we have the definition of rescue, which is the operation to retrieve person in distress. So again, the word distress. So to deliver them to a place of safety. So in the definition, it's clearly said that the rescue operation has to terminate by delivering people in a place of safety. And then we will see what means place of safety. So the first question is really what means distress? The definition is quite clear, I think. It's considered a situation where there is a reasonable certainty of grave and imminent danger which requires immediate assistance. Now, that said, at sea, scenarios might be very much different one from the others. So I guess that no one would doubt about the fact that a ship about to sink or about to capsize or a person about to die would represent a clear distress. However, there are many other situations where the question is really on the table. So in all cases where there is no imminent danger to life, this has been discussed, the practices from the states are not all the same. However, we can surely say that there is a common understanding, although no unanimity on this, but we will see this later maybe. There are important elements to assess the presence of a distress as the triggering event for SAR operations, which are the following. So according to a precautionary principle, the elements to assess distress cases are of course, the presence of an unseaworthy or substandard ship, the presence of an overcrowded ship, the presence of important medical emergencies on board, or miners on board, or deceased people on board, the lack of necessary supplies or safety equipment, particularly severe sea and weather conditions. So all these elements have to be considered to assess a distress situation, so to trigger the SAR operations. These elements, which reflect the precautionary approach, as you can see, are also mentioned in the EU Regulation 656 of 2014, which refers to the operations carried out at sea in the context of the activity of surveillance over the sea borders of the European Union. However, as I was saying, there are still cases, or there have been cases, where the distress has been considered only in the case where there was an imminent danger to the life in particular, and only at the presence of a request of distress, a request of assistance by the ship in distress. So, assuming that we or that we agree, or there is a common understanding on what is a distress, let's now try to see which is the competent SAR authority to take care of the operations and to coordinate the operations. So I will just first show you a map before going back to the slide you've just seen. The world, the seas, the oceans, and of course also the Mediterranean Sea have been divided in SAR zones, so in search and rescue zones, where each coastal state is or should be responsible of each specific SAR zones. As far as the Mediterranean Sea is concerned, there was a conference in Valencia in 1976 where coastal states have agreed, or should have agreed, to share, let's say, the sea, so to have each of them the responsibility over each SAR region. So the easy answer to the question is that every coastal state which is competent, which is responsible of the specific SAR region, has to coordinate the SAR operations, so to rescue people in distress. However, it happens, we'll see later on by giving some cases, that not always the SAR authorities are able to respond, are able to coordinate, are able to provide the adequate and effective search and rescue service in the own area of competence. For this reason, in that case, at least according to the spirit of the conventions, according to the guideline, to the IMO guidelines of 2004, the first SAR authority, which is alerted, notified of the presence of a distress event, has to take all the appropriate measures to rescue people on one side and to notify, to inform the competent SAR authority for that specific area, at least until the responsibilities are handed over to the latter. However, reality is always more complicated than theory. So there are many, as a matter of fact, elements which made this coordination not really easy. I will just mention a couple of them. If we refer to Libya, for instance, Libya has declared its own formal SAR region only at the end of 2017, and even since then, the question is open on whether and to which extent are the SAR services provided by Libya effective and adequate, so to meet the minimum standards as should be. Or another factor, the Italian SAR region partially overlaps with the Maltese SAR area, which creates some issues in case a distress event occurred precisely in that portion. And more generally, the cooperation between states, of course, is not always easy, considering how many different scenarios are at sea and how many different needs need to be met. One of the reasons which complicate things, also in terms of identification of the competent SAR authority, is the decision about the place of safety, as we will see in a few minutes. First of all, let's see what is a place of safety. The place of safety is not defined under the international conventions, which we have just looked at earlier. The place of safety is instead defined under the EU Regulation 656/2014, but it's thanks to the 2004 IMO guidelines on the treatments of persons rescued at sea, which clear light is shed on really what is a place of safety. So we can now say what is a place of safety and what is not a place of safety. The place of safety is a place where rescue operations are considered to be completed, as we have seen also under the SAR Convention earlier, and where the survivor's safety or their lives are no longer threatened, and where the primary human needs can be met, and finally where the transport of survivors to the near or final destination can be organized. So these are the main concepts which relate to the definition or better description of a place of safety. What we can say is that a place of safety cannot be so a place where people risk violence or persecution or a threat of death, and we can say that a ship can only be a temporary place of safety. People must be disembarked ashore somewhere. Somewhere, what is somewhere? We will try to see immediately. So, I will not read again. I think that I hope that the main criteria are clear. However, I put them in bold and underlined again. We can see that the state responsible of the SAR region where the distress event occurred has the primary responsibility to coordinate the operations. But nowhere here is written that the responsibility of the SAR of the state to which belong the SAR authority has the obligation to provide appraisal safety on its territory. So, but we know, as we were saying earlier, that the disembarkation must be arranged as soon as reasonably practicable, with the minimum further deviation from the ship's intended voyage. So how to really assess safety, which is the most unresolved issue probably today, as we know, at least for the large-scale SAR events, where also other implications, of course, are connected, as maybe we'll see later on. So the real question is how to decide whether the place of disembarkation, so the port, is the closest port to the place where there was a distress under a geographical point of view, or whether it's the next port of call along the itinerary if the rescue ship has been a commercial ship, a merchant ship, for instance, or whether the place of the port of disembarkation is to be on the territory of the state which is competent for the SAR region where the distress event has occurred, or instead if the port has to be on the territory of the state which has, as a matter of fact, controlled and coordinated the operations, or maybe just as a last possibility, not of a non-exhaustive list, of course, is the port equipped in best way so to meet the safety humanitarian needs of the survivors. So here is really the point. In the lack of specific express criteria and obligations, so to oblige, unequivocally at least, the states to allow disembarkation on their territories, we have so often the deadlock, the impasse, as we've seen many times in the last years. Just to make a comparison, for instance, if we go back to the European regulation 656 of 2014, which I was mentioning earlier, in that case, we have some criteria to identify which is the port of disembarkation. It's written that in the worst case scenario, the state which hosts the operation has to provide on its own territory the port of disembarkation. However, out of the scope of the application of the European Union Regulation 656, the question is still open for the absence, because the SAR legal framework does not provide the express obligation for coastal states to unequivocally, so in all cases, allow access to their ports to rescuing ships. This is because each and every time the state has to give the consent because of or due to the principle of sovereignty. So which are the consequences and which are the risks of all this? Which are the risks of this uncertainty? There are several and very important risks. So the frustration of the basic principles of law of the sea, the principles we were just in at the beginning of this talk. Violations of the provisions of refugee law, with specific reference to the non-refoulement principle. This in case people should be returned to places where they are threatened of violence or persecution and so on, or ill-treatment and so on. Risk of criminal proceedings, criminal actions brought against, in particular, as we have seen, NGO rescue ships for alleged aiding illegal immigration, violations of the European Convention on Human Rights, and then finally, of course, economic losses, if we refer in particular to merchant vessels. So these were in this second part we have seen a few of the main open issues, and in this last 15 minutes we will go through a few cases, very different from them, very different one from the other, and which in a certain way can reflect how the contribution on one side and the obligations on the other side to comply with the main obligations and principles of the SAR framework is basically the same for public ships or private ships, NGO ships or merchant ships, and so on. So the first case is an important case, the Hersey and others against Italy. The facts bring us back to 2009, when 200 more or less people from Somalia and Eritrea were intercepted at sea by the Italian Navy and sent back to Libya without that their condition was examined, and so exposing them to the risk of ill treatment. So in that case, also we are talking about a rescue operation, but in the context of an interception operation. In this case, people were returned back to Libya without assessment of the conditions. So what has found the European Court of Human Rights is that, first of all, although the conduct was not in the territory of Italy, so what was at sea, on high sea in this case, the conduct of the Italian authorities created a link so that we could say that some jurisdiction was exercised over the persons and the case under the jure point of view and de facto point of view. Under the jure point of view, because the flag, the ship was flying Italian flag and the crew was Italian, and as a de facto point of view, because there was an effective control over the situation. So under this point of view, the European Court found that the applicants were within the jurisdiction of Italy. So a very important principle has been stressed, that the non-refoulement principle applies also out of the territory of a state under this kind of circumstances. And in the specific case, the exercise of extraterritorial jurisdiction had taken the form of collective expulsion. This principle has then been mentioned in other cases which have followed to this one, and the other one I've chosen today relates to the ship Open Arms, operated by the ONG Proactiva, the Spanish ONG Proactiva Open Arms. The facts bring us back to last year, March 2018, when the ship rescued 218 people in international waters. This case is different from the previous case because what happened was that although the ship, so the master's ship, first of all, and the head of mission and all the crew were in contact and were coordinated by the Italian Maritime Coordination Rescue Center, which is the Italian SAR authority, the master decided not to comply with the indications provided by the authority. The indications provided by the authority were to hand the rescued people over on the Libyan authorities. The master decided to take the ship to Italy with a quick stop in Malta due to the serious medical conditions of a few persons on board. Once the ship arrived to Sicily, it was seized by the competent prosecutor in Catania. However, because of alleged infringement of some criminal laws with specific reference to aiding illegal immigration and coercion on top of this, we can say also. But the interesting thing is the decision taken at the end of the preliminary investigation, where the competent judge decided that actually the ship had to be released because of two reasons. The first of all is that the master of the ship had to do that because if the master had handed over onto the Libyan authorities the rescued persons would have risked an ill treatment in Libya. so in contradiction with a non-compliance with the non-refoulement principle, as we've seen already in the previous case, in the Hersey case against Italy. And then the judge has, at the end of the preliminary investigation phase, has said that the master had to do that because of the presence of the state of necessity. So the conduct was justified under the clause of justification on the state of necessity. Where the interesting issue is that the clause of necessity was not just considered as related to the specific circumstance at sea, but actually the perimeter of the state of necessity was enlarged so much to involve the conditions in Libya, so ashore. So the judge was saying the master has been justified, the conduct of the judge, the conduct of the master was justified because it had to save, to prevent, to protect the people from a higher risk once the people had been disembarked in Libya. At today's date, the proceeding in merits is still ongoing. The third case is very much different from the others. I guess I still have 5 minutes.
5 minutes. Yeah, 5 minutes.
5 minutes. Okay. It dates August 2018, when a merchant ship, the Alexander Maersk ship, so merchant vessel, had just rescued, together with Lifeline, a ship, an NGO rescue ship, more than 100 people, and then reached the port of Pozzallo in Sicily. What happened there is that the ship was blocked for a few days in the port, waiting for decisions to take regarding disembarkation of the migrants, so the survivors on board, with all the possible costs which you can imagine under a commercial point of view, an insurance point of view, under an operational point of view. The reason why I have chosen three different cases like these ones you've seen is because the stakeholders, the actors involved in the SAR operations are different. I mean, you might probably have heard about the Mare Nostrum operations, which took place for more or less 1 year between October 2013 and October 2014, which was an humanitarian and military operation led by Italian authorities, which has saved more or less 150,000 people and has caused the let's say, thanks to the operation, hundreds of people have been brought to justice. Then we will see how things will finish. But what I want to say is that after that operation, actually no real humanitarian operations have been led at a public level. So from that moment, NGO ships have intervened, as we know, in the last years. And in the absence of rescue ships or public ships, the burden of rescuing such rescue operations falls, of course, in particular also on merchant vessels. For these reasons, you found here cases which refer to private vessel, merchant vessel, rescuing and NGO ships. So, as a conclusion, what we can say that there are open discussions for sure. We can say that the SAR legal framework provides clear principles and criteria. However, it was designed not really to face search and rescue, large-scale search and rescue operations in connection with migration flows. So the result of this, and the fact that we are still far in some respect to reach unanimous consent on what is a distress, which is each and every time the SAR authority competent, or even what means actually place of safety, and on top of everything, which is the port of disembarkation, the place of safety, creates all the deadlocks and impasse and consequence which we have seen earlier. Thank you.
Thank you.
Thank you, Andrea, for this very clear and interesting presentation. Now the floor is yours, Vincent.
Thank you very much. I mean, this was indeed a very clear, didactic, and informative presentation with a very clear-cut overview of the main applicable legal norms, primarily based on the law of the sea. I will probably just add a few comments from the broader perspective of international law in order to supplement your own presentation with the focus on the law of the sea, because frankly it was clear enough and I don't have a lot to add on this. What is interesting in your presentation, you clearly explain that the basic principles, the basic definitions are quite clear on the paper, and clearly this issue raises no major difficulty if and when international law is applied in good faith. And clearly here today, the major issue is about good faith implementation of international law, and clearly it is typical dilemma has been of international law. This typical dilemma of international law has been exacerbated by the rise of populism and also political manipulations, electioneering, and so on. As recently exemplified by the new policy of Italy, among many other states. So, from when this issue is approached from with some distance, international law is also a way to recall, first of all, the normality of migration. This is a long-standing, natural human phenomenon in the history of mankind. And second, when duly applied in good faith, international law may provide an avenue, not only in terms of protection, but in terms of predictability and, of course, regular migration. So, from this perspective, clearly the very first principle at stake that is also relevant in this particular context is the right to live in a country. The right to live in a country has been restated in more than 20 universal and regional conventions, and is clearly part today to customary international law. And the right to leave any country includes, of course, departure from countries of transit. So clearly, the starting point of the role of international law is, first of all, to acknowledge the right of individuals to leave their own country. And then, of course, once after the departure, the travel as such and the duty to save life when it operates on the Mediterranean Sea has the side effect of generating the applicability of many other rights because of the notion of jurisdiction you have highlighted on the basis of the ESC case, because clearly, and as mentioned by Marco before, once jurisdiction is established, when there is a control, and this is generally the case when regarding both maritime interception and rescue operations, then once the jurisdiction is established, clearly the full panoply of basic rights are plainly applicable to the intercepted migrants, including, of course, as you mentioned, the prohibition of collective expulsion, that is crucial and was a key element in the ERC case. The principle of non-refoulement, not only under refugee law but also under human rights law, is plainly relevant here. But also the prohibition of arbitrary detention, because this is clearly relevant in the case of interception, prohibition of discrimination, torture, inhuman and degrading treatment. So clearly, once the persons are on the sea and are rescued, the jurisdiction of the boat includes the jurisdiction of the state with several important basic rights. Of course, the main issue is not at this stage because, I mean, the duty to save lives, as you mentioned, is a very long-standing tradition. Hugo Grotius already acknowledged the customary law nature of this duty during the 16th century. So clearly, this is probably one of the first typical example of a norm of customary international law. So here there is no issue. Of course, the main controversies are related to the consequence in terms of disembarkment and so on. But here again, if the definition given by the law of the sea are applied in good faith, the SAR authorities are supposed to have the primary responsibility and accordingly in the absence of any other alternatives, to be the safety place of disembarkment. And here is the main entry point after departure, interception, disembarkment is relatively well settled, but there are also other additional guarantees, because once the jurisdiction is established, if the coastal state is, the SAR authorities are not willing to ensure their primary responsibility, there is another set of rules applicable through the flag state of the boat. And here, again, as soon as the jurisdiction is established, in the absence of any alternatives, this is up to the flag state to ensure not only due respect for the basic rights, but also disembarkment in accordance with international law. And another interesting aspect is, this is not well known, but the Human Rights Committee in 1997 examined the report of France regarding the implementation of the ICCPR. And the Human Rights Committee considered that refusing disembarkment of asylum seekers in a French port constitute a violation of the right to live in any country. So here again, the right to live in any country may have some relevance, not only for allowing departure from transit countries, but also for permitting disembarkment in the destination states when there is no other alternatives, because in fact we have several alternatives, as mentioned before. SAR authorities, flag states, and the jurisdiction of the relevant state, like in the case mentioned by the Human Rights Committee a few minutes ago. So these different frameworks could be applied in a coherent way, provided that international law is applied in good faith. And clearly today, the main issue is not about international law as such. This is about the lack of implementation, sometimes the open violation of international law, and the well-known strategy that this is not new. I mean, since at least 2 decades, states are also using the ambiguities of international law in order to undermine their own responsibility. This is not fundamentally new. I mean, this is part of the official discourse since at least 2 decades. And clearly here, this is the most worrying aspect because migrants are becoming hostages of states that are no longer willing to respect for international law when it comes to migrants. And here is clearly the issue. International law is here to stay, is relatively clear, but of course the political context has drastically changed since the adoption of the convention, and especially during the last few years. And again, this is not necessarily about the lack of rules, but the lack of will to implement rules. Besides the general international law perspective, there are also several other applicable regimes. Just to mention, the smuggling protocol adopted by the UN in 2000 provides several provisions permitting interception by state parties when there is a suspicion of smuggling. And this is a quite important change because interception was traditionally limited to slavery, piracy, and so on. And now smuggling can be considered as a ground to allow interception. So, and besides this specific protocol, it is also important to recall that the Global Compact for Migration that has been adopted last December contains a specific objective on this crucial issue. Objective 8 contains a political commitment agreed on by the vast majority of UN member states to save life and to improve coordination, notably in the context of disembarkment. So clearly, the current state of international law is clear. Its validity has been restated recently in the Global Compact for Migration, and all states that have approved the Global Compact, even if this is not legally binding, this is a soft law instrument, but the very fact that there is a specific objective dedicated to this issue highlights the growing gap between the states that are willing to implement international law and the others that are outside the scope, the realm of international law. And to me, from a legal perspective, the law of the sea is relatively clear, even if the silence have been manipulated and ambiguities in order to follow political objectives. And in addition to the law of the sea, general international law, human rights law, refugee law, as well as the law governing smuggling and so on, are relatively clear. But the issue is more political. There is now the rise of populism in tandem with the rise of anti-immigrant rhetoric that are now part of the picture and represent the main threat to international law in general and the rule of law also. And this is probably here the main issue. And maybe a last word to give a slightly broader picture. The current obsession of mass media and politicians towards the so-called refugee crisis, towards migration by the Mediterranean Sea and so on, must be appraised with some distance because the so-called refugee crisis is quite disputable in the context of the European Union, at least, because at the peak in 2018, the so-called massive influx of 1.2 million of asylum seekers is relatively marginal compared to Europe and other regions, because even assuming that all asylum seekers were granted the refugee status, they represent 0.2% of the EU population. And the same year, when 1.2 million of asylum seekers came to Europe and mainly Greece, the same year Turkey were hosted more than 2 million, Lebanon 1.2, and so on. So clearly, the problem is not necessarily a legal issue. This is first of all a lack of political will, but also the way migrants are portrayed in mass media and the perceptions that are spread by televisions and other social media and so on. This issue, the lack of political will and the misperception surrounding migration are clearly the main source and the main difficulties, largely beyond the legal frameworks that you have very well presented in your presentation.
Thank you very much, Vincent. Thank you to both of you for allowing also some time for discussion and questioning the public. I don't know if Marco, you want to start with a question. So we have about 30 minutes now to discuss with our two panelists. Who would like to ask a question? Yes, please.
Hi, my name is Tilman. I'm a former student of IHl Talk and now at the ICSE. I have two questions actually, one quick one for Professor Shetai and the other one to the panelists. You mentioned the obligation of the flag state to ensure respect for international law, I guess. Would you say that if there's a German vessel, not a government vessel, but just a vessel flying a German flag, Germany has an obligation to ensure that on that ship, for example, the shipmaster doesn't do food someone? And the other question is to the two of you on the interplay of maritime law and probably refugee and human rights law. If a migrant boat or refugee boat enters, for example, the Italian territorial waters, I would say that that doesn't establish jurisdiction of Italy over that boat. And would that mean that these migrants then, or the asylum seekers, would then have the right to seek asylum in Italy, and Italy would also provide all the procedures? And if that's the case, how can Italy then just send them further to France or to Malta or to another state without assessing anything? Would that be how does that fit together? How do the two frameworks fit together? Thanks.
Interesting and complex. Thank you for the questions, of course. Let's start from the end, from the second one. And I will start from a very recent case, the Sea-Watch 3 case. Not even 1 month ago, I think. The Sea-Watch 3 case refers to a rescue operation of an ONG vessel, I think operated by a German vessel and with the Dutch flag, I think. Anyhow, the vessel reached the Sicilian coast. The Italian authorities have not allowed the access, so the migrants have been basically detained on board for some days. Why? Because there's many rhetoric, as you were saying earlier, actually, on this, but you were saying that there was no obligation upon the Italian state to allow disembarkation because there was no criteria which, in one way or another, brought entailed the ship to be the survivors to be disembarked in Italy. So what happened was that the master of the ship, the head of the mission, and a few migrants on board applied before the European Court of Human Rights as a matter of urgency. in that case, after a few days, the European Court said two things. The first was that did not grant disembarkation. So did not say you have the right to disembark. So did not oblige Italy to take measures to disembark people. But on the other side, in terms of a connection with the human rights law, as an interim measure, so as a matter of urgency, the court said to Italy to take all the appropriate measures to meet the basic needs of the people on board. In terms, of course, of water, of food, of blankets, and of course medical emergencies and so on. But as a matter of fact, I'm not aware, at least in the main cases, in the main recent cases, of the lack of assistance of the basic needs in terms of food, water, blankets, and the medical emergencies. I mean, also because of the fact that there would be no discussion about the fact that that would be, a distress or a very serious and grave and imminent danger to the life of someone. The step is to oblige a state to allow disembarkation. This is the real difficulty. And we have seen, taking another case, that even in cases where there were migrants on a public vessel, on a public Italian vessel, the Diciotti case I'm talking now, even in that case, Italian authorities have tried not to disembark people ashore. Now, that is a very extreme case in my point of view, but it's just that if these conflicts, if this approach has been taken, even in cases of people on board public vessels, I mean, it's very difficult to find the criteria to oblige a certain state. Even if you have, even if you assume that there is a strong link to assess the jurisdiction of that case, then that said, there are measures to. There are remedies. There are paths to. Of course, thank God. And we, at this point, have to choose whether to try to apply requests before international tribunals or local and so national tribunals. In the case of national tribunals, the link, either de jure or de facto, so to have a clear jurisdiction, must be extremely strong. And let's say that the list of alternatives, the list of issues, is really huge. I will just give a very small example. There is a question on whether just the fact that someone in international waters calls, so notifies SAR authority, the question is this call enough to create a link, so to say that state exercises jurisdiction over the situation? If the answer is yes, there are all the remedies also before probably the remedies before the national courts. Otherwise, it will be quite unlikely to have a successful case. As far as the first question about the flag, I don't know if you want me to go on or no. Okay, no. We've seen that the international conventions provide obligations which lie upon flag states in terms of requiring from masters to comply with all the obligations, with all the laws and regulations of the flag state. The obligation is to deliver people to a place of safety, which must be, let's say, the closest or as close as possible. It doesn't say that the port must be or can be on territory of the flag state. Then, as a matter also of politics, if the flag state was in the area of the distress of the sub-region where the distress event occurred, I personally would see quite difficult for the flag state to refuse the embarkation. also as a matter of political analysis. That is my view. I don't know if
yeah, I totally agree with you. In fact, there are several. This is a typical case for allocating jurisdictions among different titles. Under international law, quite classically, territorial jurisdiction is used to prevail over the other titles. So clearly, from this general international perspective, once the boat is within the territory, namely the territorial sea, the main responsibility is for the coastal state where the boat is within, of course, the confine of the territorial sea. This first title of jurisdiction is supposed to prevail over all others, but there are several others. So if the territorial state fails to implement its own responsibility, then the other titles can play a role. The other titles are, there is one, the jurisdiction established by the SAR authority. Generally, this is the coastal states, but I mean, so this is the second set of circumstances whereby jurisdiction is established, and accordingly the responsibility of the relevant state, here the one from whom SAR authorities are operating. And lastly, the last title is personal jurisdiction, and in this case based on the flag, the so-called nationality of the boat, but this is still a possible angle to establish the responsibility of the state and its attribution to the situation and the responsibility to protect migrants. And here we can argue, but of course this is context specific, but we can still argue that once territorial jurisdiction and SAR jurisdiction are not able to be implemented, then this is up to the flag state to ensure, to take its own responsibility, first under the law, under general international law, through the allocation of different titles of jurisdiction, and second, because in any event, migrants are within the extraterritorial jurisdiction of the flag state when they are in the boat. So clearly, from a purely normative and arguably theoretical perspective, this issue of allocation can be resolved through the basic principles of international law, starting with the territorial jurisdiction, then the SAR jurisdiction, and the personal jurisdiction. Of course, this is the flag states could be competent in very exceptional circumstances, but we can still legally argue that there is a possible avenue when the two other titles of jurisdiction are not working.
We have two questions in the front row. First,
Yes.
and then you.
My name is Giuseppe De Giorgi. I'm the former chief of the Italian Navy, Mare Nostrum. You just reminded that. Say I'm the officer who started Mare Nostrum in the night, right in the morning after the disaster in front of Lampedusa, waiting for instruction from the government. I started it on my authority as chief of the Navy, and then it lasted 12 months. Now the mission, as you know, was to capture these pirates, and first of all, it was a humanitarian mission. So not so much a search and rescue mission, but a humanitarian mission. So it started with a completely different set of rules. So we are not very surgical in defining if and when we're going to save someone. As soon as we found an overcrowded boat of any sort, we would intervene, take them on board, and then bring them home, bring them to Italy. So that was a very peculiar period. It changed dramatically when the new government came, or actually before the new government came, when it became politically not so popular anymore. We're so proud about Mare Nostrum, all the Navy, we're proud, we're our pride. Then it became a very difficult topic this thing about going and saving people. So we had to switch to Mare Sicuro, which for a military-oriented operation, because ISIS was in Libya for so many different reasons. Now, the point, my question actually is this one. Of course, the law of the sea, as generally is called properly, I mean, it provides the obligation to save people at sea, but it was not laid down having in mind a massive phenomenon like migration. So it was like a merchant ship going down, 12 people were saved, they all had their families, their homes, they had passports. So the obligation for the captain of the ship was to bring them to the safest place with the less expense for the master of the ship, for the owner of the ship. Once they arrived ashore, they were assisted by their embassies and consulates, and they, would go home. So here we are with a set of rules that are very inadequate to deal with this massive phenomenon of migration. I'm personally, ideologically in favor of the open borders, because I think the migration and immigrants are an opportunity. So what I'm saying here that has nothing to do with my beliefs, political beliefs. But I think that when you have to tackle this issue, you have to keep in mind that you cannot illegally enter a nation on a massive scale without any sort of clearance of scrutiny. And we face only a minority of refugees. Only 10% of the people arriving in Italy, I'm talking from my country, is actually coming with the credentials or even the locations from which you could apply the title of refugee. The others, respectfully, because they have the right to look and search for a better life, are economic travelers, are economic migrants. And when you go to work in another place, you need to have a visa, you have to need some sort of permission. So I do understand the problem in terms of security and social control in having to deal with this mass of people coming in illegally. So I think that here, one of the problems that we had that also helped the populist parties was this, naive kind of approach toward this issue, by which we were all black or all white. I think that we have to define new rules by which we could deal more effectively with the situation. Because otherwise, the populists will win forever, because there's nothing like the scare of a black man that allows people to fuel the fear for the foreigner. And I'm not sure that the international law is so clear-cut in condemning a nation that does not allow to disembark people who are no more in danger of their life. For what concerns the
Can I just ask you to...
Yes, just cut it down.
Because
the flag issue. The flag issue was one of our problems. The flag issue, in our belief, only is limited to the military ships. They maintain sovereignty in international waters. The merchant ships, they have the jurisdiction on board their ship when they are in international waters, but they don't bring it with them when they are in national waters. So when you're saved by a military German ship, Germany at that point has full responsibility. And this, up to now, didn't carry on any consequence, just because Sofia, the European mission, started only because the European nations were guaranteed that anyhow all the migrants would have been disembarked in Italy. So the flag issue is very, very complex, not so straightforward. Thank you.
Thank you. Do you want to comment, or?
Very, very short, because I fully agree that there is one of the key issue is really ashore, not only at sea. Today we discussed about what happens at sea and which are the obligations and where obligations, search and rescue activities terminate. So by providing a place of safety, then under political standpoint, I fully agree that if there was a mechanism to share the burden of the follow-up, let's say after the vacation, as a consequence, all the complexities regarding the identification of the place of safety would be, would be really minimized and would decrease really a lot. Absolutely, I agree on this. So.
Thank you. So we have about 10 minutes for, let's say, 3 more questions. I have one gentleman here, you, and then you'll have the last question. Please.
Yes, Boris Engelson, a jurist with no heart and no brain. First, a very short remark. You started with the metaphor, the myth of Aeneas. One should not forget that Aeneas was rescued by Didon, and it is this excess of love, not hatred, of love and mutual interest, which led to 3 Punic wars. And I think there is it's not a joke. There is a lot to think about. My question, don't take it ill. It's not ill-intended. I am really curious to compare how sea law compares with land law. For instance, if Western Europe is bankrupt and we all want to migrate to China, and we organize migration through Siberia, the Khyber Pass, etc. And before starting, we are warned by our government, their government, the middle government, that it's folly and we will all die. That we should not put 100 people in a 3-seat second-hand aircraft by adverse meteorological conditions, etc. And if in spite of all that we do, what does the overland law say? It's a genuine question. It's not to embarrass you or refute what you have said so splendidly. Same, likewise, what does do the law on piracy say? If I am being attacked and I wreck the ship, or even just if I see a wrecked ship with pirates, should I? What does the law say? Not your heart or your brain. What does the law say about my duty to rescue?
Thank you.
So, I see we have 10 minutes with 3 answers.
Yeah.
Actually, the main difference between the laws or the principles, let's say, between the migrations on land or at sea, is that in this case, all our reflections also all our discussion takes origin from the presence of a distress, which which is a peculiarity of maritime law in this case. So, frankly, I would not be able to consider an analogy with inland migration. We should consider a certain case of distress also on land. What I can say is that at least under Italian law, but then we can widen a bit the point of under European law. There is a principle which says that independently from whether people come from sea or from land, if there is a humanitarian scope, so there is the need to assist someone, this is not punishable under a criminal point of view. So this is, a principle which applies to both cases, land or not, where the difference was the distress, which applies to sea and not to land. Concerning Aeneas, it was just really an example, belonging to not history but legend. To see how
love kills much more than hatred.
Yes. Okay. I don't go so far. I don't go so far. The motivation was just, a way to say that my Mediterranean Sea has been crossed in any direction already thousands of years or years ago. But I fully see the point.
Thank you. So perhaps we should ask the 2 questions together so that the speakers can wrap up. Please.
All right. Thank you very much. My name is Daniel Buchanan. I'm a visiting fellow at the Academy. And my question is related to another dimension of the migration crisis in the Mediterranean region, which is in particular one aspect of the crisis happening on the other side of the Mediterranean Sea. So I understand that your focus is more into the obligation of states from the European shore, obligations in particular of rescue and search obligations based on what we have already discussed under the law, in the context of the broader area of maritime law. Perhaps there is another important element, and in particular since December 2017, there is overwhelming evidence of complicity of European actors, in particular Italy and the European Union, for violations that are actually happening back in Libya, not even in the high seas. And these are very, very serious accusations that amount to, crimes punishable by the wrong side of the International Criminal Court if any other actions are not taken by concerned countries in Europe. I don't know how much does this topic or this issue relate to your presentation. If you think it's not related at all, you can simply ignore my question. But I think it's a very part and parcel of the migration crisis in the whole Mediterranean region, and we cannot simply ignore it as such. So that's why I'm trying to put it from a different perspective, and I would love to hear your views on that, maybe also the view of Professor Shatai as well. Thank you.
Last question, please.
I'm Julie Melisha from SOS Mediterranean, which used to charge the Aquarius and NGO rescue ship. And my question is a rather speculative one. We've seen how much political pressure can do to change the situation, sometimes contrary to the law. And I'm thinking, for instance, of the creation of the Libyan Search and Rescue Region and Coordination Center, which does not comply with the requirements and nonetheless exists. And I was wondering to what extent you think that there could be a reopening of parts of the SAR legal framework to redefine some of its aspects. And I'm thinking specifically of the place of safety concept and whether political pressure could lead the IMO to redefine the way place of safety is currently defined so as to include other countries that are not included.
Thank you very much.
Surely it's there are many connections between this presentation and what happens in Libya. Absolutely. I'm not sure that I just want to be sure that I just got the point. The point is the link between or the impact or to which extent we should consider situation in Libya. So the impact of the situation in Libya on the SAR activities. This is really your point.
I can briefly clarify. Not only that, there is overwhelming evidence. I can particularly refer to you. A report by Amnesty International from December 2017, which makes strong conclusions showing at least alleged complicity of Italy and the European Union. And according to the report, the allegation is that they are sending money to armed, safe and non-safe armed groups in Libya, which are abusing African migrants and refugees. And that clearly establishes obligations under international law because they are violating international norms and principles. So, what accountability measures do we have for that?
It's a discussion that we can have at a political under a political standpoint. Not really under before then under a legal standpoint. It's for some reasons Europe decided that needed someone in Libya to minimize the risk. As a matter of fact, to minimize and so to lower the number of people embarking and so leaving. One of the ways has been to recognize, formally speaking, a Libyan SAR region, and to fund and to train in one way or another people in Libya to carry out operations at sea. Now, the real contradiction, I mean, I fully agree that there is a real contradiction on the fact that on one side, Europe, and also Italy, but Europe in general, I would say, invests in this way to fund and train people in Libya on one side, but on the other side, there is objective recognition that not only from international organizations, but also from, for instance, some Italian judges, who say that Libya is not a safe place. So the same persons who have to rescue and search and rescue people, then are the ones who formally would be entitled to return back these people in a place where it's, as a matter of fact, obvious that there are no. So, but it's a political choice, which, I mean, personally, I can tell you that I disagree, but I mean, it's just my point of view. But as a matter of fact, there is the contradiction. Regarding the Libyan SAR region, I mean, if we look at if we start from the wording of the articles, states must provide, have the obligation to provide adequate and effective search and rescue services, and which means that there is a minimum level, a minimum acceptable level of diligence in doing that. In case states, Libya in this case, fail to do that, I mean, states and Europe are invited to put pressure on the IMO. I mean, to put the issue on the table. We also to say that it's not the IMO declaration which makes, as a matter of fact, a SAR region effective. I mean, it's formally on the list of the regions, but this is very far from saying that it meets the minimum standards and international point of view.
Maybe clearly the two questions are the perfect illustration of a long-standing political temptation of European states to externalize immigration control. This is not new. I mean, this strategy of containment and externalization is a recurrent temptation since at least 2 and probably 3 decades. And of course, clearly there is a political objective. Clearly. And again, we should do a distinction between the legal framework and the political agenda. And clearly, the political agenda is first containment through humanitarian assistance, refugee camps in countries of origins, and so on. And second, through externalization of immigration control in order to establish states at the external border of the EU, the new gatekeeper of the EU territory. And clearly, what's happened with Libya regarding the SAR responsibility, but also regarding the alleged violation of international law carried out in other states, is alongside his political agenda. But again, I mean, politics is a major component of the picture, but of course states have to work with existing rules of international law. So here, there is a difficult dialogue between political objectives that are clearly oriented towards immigration control and more today than ever, and on the other hand, a legal framework that is more balanced and more rational to some extent than the current political atmosphere. So the two examples you mentioned are the perfect illustration of the political will of the EU, but on the other hand, generally speaking, the EU is used to not violate openly international law. So TC is generally used through political means, through alternative interpretations, and so on. And clearly today we are at the crossroad between T's more or less political agenda and the will, at least among most EU states, to continue to pay tribute to international law. And clearly now the politics is clearly driven by immigration control, but framed and constrained by international law. This is the current situation today, and we will see in the future if international law will continue to play its role as a safety net against political manipulations. And frankly, given the last events in Italy, we don't know what will happen, and if international law will be robust enough to take into account this frontal political attack raised by many new political movements.
Can I just compliment what you just stated about the Amnesty International report? Please be aware that that report has factual mistakes. I know it almost by heart. My name is Rusty Popiani, Webster University, but I also worked as political advisor to the Command of Operation Sophia, which is not an operation to rescue life at sea, as you know. Originally, it was an operation to combat trafficking in human beings at sea. Then they added other functions along the way. But during the 15-17 period, if you analyze this operation, what they say in this famous report, you can find at least 10, 15 factual mistakes. If you can offer a very small piece of advice, you better read Roberto Mignone report, UNHCR, the chief of mission of the UNHCR in Libya, and then the IOM report. That report by Amnesty International, unfortunately, is unbalanced, to say the least.
Okay, so with that, we are closing our discussion. Please join me in thanking our two excellent panelists.